get it.
Good afternoon, Your Excellencies.
How are you?
My name is Adam Maxwell. I represent, along with co-agent Scott Woods, the Commonwealth of Revisia. I will be addressing issues 1 and 3 regarding humanitarian intervention in Alicanto and the issues regarding radio, broadcasting, and sexual exploitation. I will talk for 22 minutes. Scott Woods will talk for 22 minutes, and at this time we'd like to reserve 3 minutes for rebuttal. Thank you. We submit to the court that Revisia's intervention is justified and legal based on any one of 3 independent grounds. First, as collective self-defense. Second, as a regionally authorized intervention. And third, Revisia's intervention is justified under the customary law doctrine of humanitarian intervention. The first point on this issue is that Revisia is fully justified after the termination of UNMORPH under collective self-defense. The UN Charter requires first an armed attack, and that the armed attack has a sufficient nexus to the state where the action of self-defense will be carried out. Security Council Resolution 6620 affirmed that the situation in Alicanto was unresolved, and this resolution came about just days before the termination of the mandate. And it also said that, that the situation there remained a continuing threat to the peace and security in the region. Now I'd like to mention that Alicanto has consistently stood by and not taken action against the violence. They've taken no measure to remedy the situation, and Resolution 6620 states this. This is where collective self-defense is justified under Article 51, where the Security Council has failed to act, and the intervention's purpose, among others, is to quell the threat to the peace.
What specific acts of violence are you referring to?
Your Excellency, there was a shooting down of a New Benue plane. It was a surveillance plane in May of 2005. This event escalated the situation in Alicanto, and it gave rise to the UN action, UNMORPH. The second point on this issue
what is I guess the question is, what, after the UN mandate expired, what other actions or what other acts of violence
of women and others, that these disturb the order public because the content somehow infuriates people.
Are you saying that there are no cultural considerations taken into effect before a radio broadcast are put out? It's purely based on whether or not you violate the strict reading of their law?
Could you repeat the question? I'm not sure if I need to answer yes or no.
Your Revisian radio broadcast directed towards the Alicante public. Are you saying that as long as it is in a strict reading of the Alicantan law, it's in accordance with that it does not need to take into consideration the Alicantan cultural community awareness?
Oh, no, Your Excellency, we're not saying that. The radio broadcast may have incited some problems initially, but the broadcasts are now preceded by a warning that, and this is also in regard to respecting the Alicantan laws under the SOFA. They're preceded by warnings out of respect for the culture and attempting to put an end to these type of allegations. Now, the second point on this issue is that this is a provincial ordinance, and it's trumped by Alicantan national law as agreed to under its international obligations. Although it's not found in our memorial, even if Revisia is found to be in violation of the prior approval ordinance, the issue of reparations are not ripe and reparations would not be proper. The first remedy would be to make Revisia comply with the ordinance. Then, only upon Alicanto's disapproval and Revisia's continuing broadcast would Revisia be in violation. We ask the court to find that radio broadcasting at Camp Terra has been lawful at all times, and that any event reparations for this alleged violation are not proper.
Just so I understand, you're basically saying the ordinance violates a fundamental human right.
Yes, Your Honor, that is one argument.
And therefore, it would have been, moot entirely. I mean, the whole issue of the broadcast violating this ordinance is trumped by the fact that the ordinance itself is unlawful.
Yes, Your Honor, that is our initial argument, and also that the issue's not right because we actually do not submit, and therefore their disapproval would have to take place first for us to be in violation.
Thanks, go on.
I'll now address the sexual exploitation that occurred in Camp Terra during Operation Unmorph. I'd like to remind the court that all exploitation occurred during Unmorph, and there are no allegations of exploitation by OPS troops. As such, all conduct was governed by the SOFA as established in my discussion of radio broadcasting. Under Article 47 of the SOFA, Revicia has exclusive jurisdiction to prosecute. This was misconduct. This was individual misconduct, Your Excellencies. If we were to hold a country responsible for a small amount of individual misconduct, these agreements, the SOFA and Security Council resolutions after agreements like this will cease to exist. Intervention will simply cease to exist, where another body can come in and establish liability post facto for prosecuting or not prosecuting, which is inherently a discretionary function. Additionally, Revicia has investigated, and nothing in the compromise indicates that exploitation has occurred or has continued to occur after the termination of Unmorph. Also under the SOFA, all members shall be immune from legal process in respect of all acts performed by them in their official capacity. It's important to emphasize that a determination of official capacity would not even constitute a waiver of immunity, as that decision lies with the Secretary General per the Convention on the Privileges and Immunities. Since the Secretary General has not waived the privileges and immunities provided to troops through the SOFA, no determination of liability can be made on that issue.
So let me make sure I'm clear on this. I may be confusing the waiver of immunity and their status. So you're saying that there is no boundary for the determination of official status as a soldier? They could potentially commit any crime and it would be covered under this waiver and immunity?
No, Your Excellency. I was simply stating that a determination of whether it is in or whether it is within or not within a soldier's official capacity has no bearing on the effect of the waiver of the privileges and immunities. Is that
what boundary would you have a crime be? At what point does a crime step over the boundary of not being an official capacity?
Your Excellency, I'm not aware of a standard, and I'm unsure, but I don't think that issue, that determination is at issue here or needs to be determined. Just that the privileges and immunities afforded to the troops has not been waived.
Maybe what I heard from the other side was that sexual misconduct, alleged sexual misconduct with children rose to a level of them going beyond their official capacity as soldiers.
I understand, Your Excellency. I believe that the determination, well, first of all, that's a UN policy, and the Secretary General does have the ability to waive privileges and immunities. If that is his policy, he would have waived the privileges and immunities, and he has not done so in this case.
But it's not attributable to Revicia?
No, it's not.
Because all the misconduct allegedly occurred under the Unmorph mandate, correct?
Yes, Your Excellency, that's correct. Applicant may normally seek reparations for the breach of treaty obligations. However, Revicia has not, I see I'm out of time, may I be allowed to conclude?
Yes, you may.
Revicia has not violated any obligations where the conduct in question is not governed by the privileges and immunities of the SOFA. If not completely immune from liability under the SOFA, then Revicia has exclusive jurisdiction to determine reparations for exploitation. We ask this court to find the applicant is not entitled to seek material or non-material reparations under customary law of state responsibility in this court. Thank you.
Thank you.